Your hosts, Kate Brewer, succession law barrister extraordinaire, and Michelle Davis, lawyer, educator, and succession nerd, have a mutual love and deep interest in all things succession law. In this podcast, Kate and Michelle share stories, thoughts, and considerations of wills, estates, trusts, and succession case law from around Australia. Join us on the airwaves for all things succession law, and be sure to subscribe and follow the podcast for all the latest episodes. Please know that the information provided in this podcast is for general information and educational purposes only and should not be construed as legal advice under any circumstances. Please get specific legal advice for your particular circumstances. Any views or opinions expressed by our hosts or any of our guests are the personal views of that person and are not representative of their employers or any organisations or bodies of which they are affiliated. Well, hello there and welcome to today's episode. I am elated to be back, and I've got to say, Kate, I don't know about you, but I have been getting some excellent feedback from everyone.
It's been really good. Yeah. Hi, Michelle. Hi, everybody. Nice to be back.
Yeah, it's really great. It's been really quite humbling, hasn't it? Just to hear everyone's being so positive about, us nerding it out on the airwaves.
It has. And we welcome your feedback, and we certainly welcome questions that we can address in any future episodes as well. So send them through on our email.
Yes, absolutely. We love to hear it because it's just excellent. It's good to know that people are sort of on the same wavelength about the issues that we think are interesting. So it's really, really valuable for us to hear that from our audience. So thank you to those that have sent through. And yes, absolutely, please send them through if anyone is listening and go, oh, I wouldn't mind talking about that. That would be fantastic. Well, let's get into it. Hey, Kate.
Yeah.
So today we've got a couple of things we're going to go through. The first of which is we've had a question come through from our lovely audience about our last episode, which was To Love and To Loathe, about statutory declarations used in estate planning and the litigation, as it is referred to as the litigator's dream sometimes. So we thought we'll go through that a little bit and hopefully give some guidance there. Then I'm going to hand over to Kate, and Kate's going to talk through the case of Re Marsella and what that is all about and why it's important for us all to know. Then we're going to move on to a bit of a new segment we're going to try out, which is things I've learned from episode to episode, effectively. And then last but not least, we will go through and give you a bit of a snapshot into what our next episode is going to look like. So without further ado, let's get into it. I'm going to read out the question that we had from one of our lovely audience members about our last episode, To Love and To Loathe. And the question is, hi, Kate and Michelle. In your episode, To Love and To Loathe, you discussed the statutory declarations are a litigator's dream and not a good way of providing evidence of why an exclusion is made. If a testator is adamant that they want to exclude a particular beneficiary, what is the best method of making their wishes come true? Now, I think given this is the litigator's dream, I think, Kate, you're going to want to have to comment on this, I imagine.
I'm certainly happy to take this one, Michelle. So can I start off by saying that the reason mostly that statutory declarations or any kind of statement by the testator as to why they might be excluding somebody, the reason why mostly they're useless in court is that such a statement is admissible as to the reason why a testator might have done something. But it's a little bit like when you're talking about expert reports. An expert can give an opinion on something, but they've got to give an opinion based upon facts that are proven in the trial. If those facts aren't proven, then the expert's opinion is not admissible because the facts that underlie it aren't proven facts in the trial. So, for example, if a testator, so it's a similar kind of situation. If a testator says in a statement, the reason that I cut Michelle out of my will is because on the 15th of July, 2021, she tried to run me down in her car and told me that she was going to kill me. Now, it might be that is then admissible as the reason why I cut Michelle out of my will, but that doesn't prove that on the 15th of July, 2021, Michelle tried to run me down in her car and told me that she was going to kill me. You've got to then look at, well, what is the evidence that would need to be proved in order for that statement of wishes, those reasons to be given any effect. So firstly, that Michelle tried to run me down in her car. Now, how do you prove that? a statement written by the testator that Michelle tried to run me down in her car, that's not going to prove that fact. You would have to go into a lot more detail for a court to be able to find that had indeed happened as a fact. The second one, that Michelle told me she was going to kill me. Well, when did she tell you that? How was that expressed to you? Was it via a text message? Was it orally? There's so many questions that arise out of that. So, for example, if you do have a testator who is, somebody says, hell-bent on wanting to make a statutory declaration so that the court knows of their reasons, one of the things that you could do to ensure that might actually be useful at the end of the day is to brief somebody who, either a counsel or an experienced estate litigation solicitor, as to, well, how would you get this admitted in a trial, and how would you prove those underlying facts that are in the statement? And you would then need to go and get that evidence at that point in time so that it could be. Another example that I've had in the past is where somebody says, I didn't provide for somebody because I had provided for them. I bought them a business and then they failed in that business. And you're trying then 20 years later to prove that underlying fact, and there's just no evidence at all that is obtainable about it, because often it's only known to the testator who's now deceased, and the other beneficiary who's been excluded would have a completely different story. So they're still alive, they've got their story to tell. The testator's story hasn't been tested and hasn't been, there's no way of proving it by admissible evidence. So if, for example, I was briefed now with a statement like that by somebody, I'd just be saying, okay, well, where are the financial documents that prove that you invested in a business in that person's name? Give me the bank statements, give me the contracts showing that it was in that name. Get all of that evidence together, because somebody trying to find that 10, 15, 20 years down the track, it can be impossible. And so it can be impossible to prove those underlying facts. So it means that there will be absolutely no weight given to the testator's statements, because you can't prove the underlying facts. Likewise, the beneficiary might be able to prove some underlying facts that are the opposite to what the testator's based it on. And that's where we say it's a litigator's dream, because it's often easy to prove the opposite to those underlying facts. And therefore, not only is it that the testator's statement isn't given any weight, they actually are made to look like they're a bit of a lunatic, or just in some way have got the situation completely wrong, because they're not there to give the evidence. And if they haven't told their solicitor at the time where that evidence might be able to be found, or actually given that evidence over, there's just no weight that can be given to it. And more often than not, it's helpful to the other side.
Yeah, thanks for that, Kate, because I think it's really difficult, particularly from an estate planning perspective, that some clients really want to have their say about certain purpose or reasons behind why they've done what they've done in their will, and it can be really difficult to manage that situation sometimes. So I think it's really good to perhaps give them some explanation as to why it might be good, bad, or indifferent about doing a stat dec, and perhaps do indeed what you've said before, which is to actually get counsel to settle a declaration that might actually be really useful in potential litigation in the future, because, as I said, it can be a particularly difficult thing. It might make it worse before it makes it better. But at least they'll have the opportunity to really put something that can be properly used for their benefit and trying to uphold their wishes as they've set them out. So I think that might be something that, if they really are adamant, that perhaps they might need to put more effort perhaps into building a statutory declaration that is actually really useful from a litigation trial evidence perspective.
Yeah, good idea, Michelle.
Yeah. All right. Well, look, thanks again so much for that question to us. We really do appreciate it. And we hopefully that's been offering a little bit of guidance as to the reasons why we've gone through what we went through in our last episode. But yeah, as I said, please do give us more questions as and when they come through for you. But let's move on to our next case. So as I mentioned earlier, Kate is going to take us through the case that many of us may already know, but let's talk about it anyway, the case of Re Marsella. Over to you, Kate. Tell us all about it.
this is a case from, I think it was 2016 or 2017 from the Victorian Supreme Court and Justice Macmillan, and it concerned a trustee distributing the death benefits from a self-managed super fund to herself. So Helen Marsella was the name of the deceased, and she died in April 2016 and was survived by her husband and 2 children from a previous marriage, Carolyn and Charles. Now, the husband was the executor of her estate, and he was the plaintiff in this matter. In 2003, the deceased had founded a self-managed super fund called the Swanston Superannuation Fund, and she used this to manage her retirement funds. The deceased and her daughter Caroline were appointed trustees of the fund, and the deceased was the only member. Now, pursuant to the trustee, the office of the trustee was to be held by 2 or more individual trustees or a corporate trustee, which is the standard thing for self-managed super funds. After the death of the deceased, Caroline, of course, was the sole remaining trustee at that point, and so she appointed her husband Martin as a co-trustee with her in order to satisfy that relevant clause of the trustee and that requirement. In fact, that's the requirement under the SIS Act, I'm pretty sure. So Carol and Martin were the first and second defendants in the matter, remembering that the deceased husband was the first. The death benefit payable was actually about $450,000. So it was a substantial sum. And the deceased husband had also brought a family provision application in the estate. The deceased had previously executed a binding nomination in favour of her grandchildren, but that had expired and there was no other written nomination had been executed. So there was no question of any binding nomination. The trust deed provided that in circumstances where there was no binding nomination in effect, that the death benefit could be paid to one or more of the dependents of or the LPR of the deceased member. The payment could be in such proportions as the trustee shall determine in its absolute discretion. So it was a completely discretionary deed, and at this point it was Caroline and Martin who were exercising that discretion. Now, dependent was defined to include the widower of a member and any child of the member. On the 17th of April 2017, Caroline and Martin, as trustees of the fund, exercised their discretion and resolved to pay the entire death benefit to Caroline. Now, this decision was made after the accountant who had prepared the fund deed impressed upon Caroline that the death benefits had to be paid as soon as practicable. Now, we know that that's a requirement under the SIS Act as well. The minutes of the resolution stated that the trustees had made the decision after due consideration having been made by the surviving trustee of the possible interests of all dependents of the deceased member, the potential eligible beneficiaries of the member, and the member's estate. The minutes were prepared with the assistance of solicitors. On the 26th of April, the plaintiffs, that's the husbands, solicitors wrote to the trustees' solicitors seeking some explanations in relation to the sale of assets of the fund. The trustees' solicitor responded to that correspondence, asserting that the plaintiff is neither a member, trustee or beneficiary of the fund, and as such, the trustee was not required to consult with him on any matter relating to the administration of the fund, nor provide any undertakings or accounting to him. It was further asserted that the trustees had an absolute and unfettered discretion in relation to the resolution to distribute the proceeds of the fund. Now, that may have been strictly true, that last sentence, but of course it was sort of stated in a high-handed way, and that correspondence really came back to bite the defendants at the end of the day. The plaintiff husband in the proceeding that was brought in the Supreme Court of Victoria sought the removal of Caroline and Martin as trustees of the fund and the appointment of a new trustee, and in order that Caroline and Martin repay the sum paid plus interest. Well, really, it was Caroline repay the sum paid because it was paid to her plus interest. The issues in the dispute were, firstly, whether the trustees properly exercised their discretion as trustees in resolving to distribute the proceeds of the fund, including whether they acted in good faith and upon real and genuine considerations and in accordance with the purpose for which the power was conferred. And secondly, whether Caroline and Martin should be removed as trustees. Now, the estate, as I mentioned before, was also subject to an application for further provision by the deceased husband. In the judgment for those proceedings, the court found that upon the death of the deceased, Caroline had exhibited a marked negative attitude towards the deceased husband and found that their relationship had broken down irretrievably. Now, In her judgment, Justice Macmillan stated the applicable principles as follows. Firstly, in accepting office, a trustee becomes bound by certain duties, including becoming familiar with the terms of the trust instrument and exercising their powers in the best interests of the beneficiaries. Secondly, whilst a trust instrument may afford the trustee absolute and unfettered discretion, that discretion must be exercised in good faith upon real and genuine considerations and in accordance with the purpose for which the discretion was conferred. In considering this question, the court may look at the inquiries the trustee made, the information they had, and their reasons for and manner of exercising their discretion. This includes a consideration of any gaps or errors in the information. Thirdly, it's not the court's role to determine the weight the trustee should have attributed to relevant matters in exercising its discretion, or to decide how the power should have been exercised or the wisdom of its exercise. A lack of good faith or mala fides encompasses more than just fraud. It may include the taking into account of irrelevant considerations and a refusal to take into account relevant considerations. Whilst unreasonableness of itself isn't a ground for interference by the court, it may form evidence that a discretion was never really exercised at all, or evidence of mala fides. Fifthly, a grotesquely unreasonable result may be evidence of a miscarriage of duty. However, mere carelessness or honest blundering will not amount to mala fides. The trustee must inform themselves of the matters relevant to the decision. If consideration is not properly informed, then it is not genuine. There must be the exercise of an active discretion. The purpose for which the power is conferred on the trustee has to be inferred from the trust deed itself. Whether a trustee exercised a power for a proper purpose is a question of fact to be decided on the evidence. A trustee is not bound to disclose their reasons in reaching a particular decision, and a negative inference cannot be drawn from the non-disclosure by a trustee of the reasons for their decision. The findings of Her Honour were that although Carolyn fell within the class of objects identified in the power of distribution within the relevant clause of the trust deed. This, in other words, even though she was a potential beneficiary, this did not negate her duty to exercise the power as trustee in good faith upon real and genuine considerations and for the purposes for which the power was conferred. Her Honour found that a donee of a fiduciary power ought to be more vigilant when discharging that power in their own favour, such as here, Carolyn was not and exercised her discretion under misapprehensions as to the terms of the trust deed, as to the terms of the duties that she owed to the plaintiff, and of the relevance of the plaintiff's role as executor of the deceased estate. Carolyn's assertion in writing by her solicitors that the plaintiff was not a beneficiary was inconsistent with the definition of beneficiary in the trust deed, which included widower of the deceased member, and also it included him in his capacity as executor of her estate. So this was despite it being Carolyn's duty to familiarise herself with the terms of the fund deed. She was here asserting through solicitors that he had no interest and no right to any information at all. So in this case, in order for there to have been a real and genuine consideration in exercising the discretion, Justice Macmillan held that Carolyn ought to have considered the intention of the deceased, the relationship between the deceased and her dependents, and the financial circumstances and needs of the dependents. However, even assuming that the deceased did not intend the plaintiff, that's her husband, to benefit from the fund, ignoring his relationship with the deceased as husband and wife and neglecting the fact that he had very limited financial circumstances, demonstrated a failure by Carolyn to take into account relevant considerations in exercising the discretion. Additionally, Carolyn failed to make a distribution to her brother, which was inconsistent with her own submissions at the trial that the deceased had intended to benefit her own children and grandchildren with the fund. There was also uncertainty in relation to the required number of trustees of the fund. Although the accountant for the fund had advised Caroline that she should seek specialist advice in relation to this, she didn't, and she failed to resolve that uncertainty despite being required to make a significant financial decision in distributing the death benefits of the fund, which were just under $500,000. So Justice Macmillan considered that, on balance, Caroline acted arbitrarily in distributing the fund with ignorance of or insolence towards her duties as trustee. She acted in the context of uncertainty and had misapprehensions as to the identity of a beneficiary, as to her duties as trustee, and as to her position of conflict. Therefore, she wasn't in a position to give real and genuine considerations to the interests of all of the dependents. Her Honour described the decision by Caroline as involving ill-informed arbitrariness, and stated that this amounted to bad faith as her conduct was beyond mere carelessness or honest blundering. She held that Caroline's husband, Martin, acted carelessly but not in bad faith. However, he did act in breach of his duty to avoid conflict. Although the exercise of Caroline's discretion was in bad faith and without real and genuine consideration, Her Honour did hold that it was not made for an improper purpose. She wasn't clear here, or she thought that the evidence wasn't clear here, whether Caroline's arbitrariness and lack of consideration were on account of her personal animosity towards the plaintiff or her need that had been advised by the accountant to distribute the funds as soon as possible. Of course, it didn't make any difference because she'd found the bad faith and without real and genuine consideration in any event. In relation to the appointment of Martin as trustee, that's her husband as the co-trustee, Justice Macmillan found that the appointment did little to alleviate the conflict between Caroline and the deceased husband. In fact, this appointment really served to compound the personal acrimony between the parties. Her Honour held that in all of the circumstances, particularly in light of the size of the fund and the complexities surrounding the fund deed and the compliance with the SIS Act, that specialist advice appeared to have been justified as had been recommended to her, and she should have obtained it. Her Honour made an order that the trustees be removed as trustees of the fund, as they had failed to exercise the discretion afforded to them by not giving real and genuine considerations to the interests of the dependents. They'd acted arbitrarily in distributing the proceeds of the fund, and they did so in the context of substantial personal conflict. It was further ordered that the exercise of the discretion to pay the proceeds of the fund to Caroline was to be set aside. So, Michelle, it was a pretty big decision when it came down. It's the first case that I'm aware of the trustee of the self-managed super fund being removed from that role and the exercise of discretion being overturned.
Yeah, I absolutely find this case really fascinating, Kate. I'm so glad that you've talked to it today because as an estate planner, my mind just boggles as to how to manage super when it's a discretion like that. But then these sorts of cases come up and you go, oh, golly, okay, what must someone do when it comes to making that discretion and exercising that discretion, where, people do appoint the child or children to put in that position so they have the decision-making capacity. And it's just not that simple, is it? I mean, this is an example.
Certainly not. Yeah. Certainly not that simple. And I think number one takeaway rule is that the exercise of discretion in relation to the payment of death benefits in self-managed super funds is a complex area.
Yes,
you really do need to get advice from somebody who specialises in that area.
Yeah.
Number one thing, as a well-known speaker often says, the first thing with superannuation disputes is read the deed, read the deed, read the deed.
That's
so
right.
To not even to be the trustee of a fund or to be a solicitor, imagine being the solicitor who'd written that letter in this case, to be a solicitor acting as the trustee of a fund and to not even know who it is that are the potential discretionary objects. That's a pretty big misapprehension from the start. So, of course, from a practical point of view, if you are advising a trustee, the first thing is to read the deed. Read the deed, be familiar with the SIS Act and regulations as to who can be potential beneficiaries of the fund. Is there a binding nomination? Is that binding nomination valid? Just because there's a binding nomination doesn't mean that it is. Does anybody have anything to say do any of those other potential beneficiaries have anything to say about whether or not the binding nomination's valid? Do you need to get advice on whether or not the binding nomination's valid? I've just done one this week.
Yeah.
And I do them fairly regularly nowadays. It's a pretty big litigious area, superannuation death benefits, because, of course, a lot more wealth is being transferred through superannuation nowadays than often through estates. So it's fairly big. But, of course, this decision is much broader than just the superannuation context, because it's family discretionary trusts happen all the time. Decisions are, people are put into, they run businesses through trusts because that's the structure that the accountant told them to put it into. At the end of the financial year, usually the trustee or the accountant says, oh, here's some resolutions, sign here. Where's the real and genuine consideration as to who those discretionary objects could be, should be, as to why they should just make a distribution in a particular way? And I mean, these are people running businesses through trusts. You have an errant child who is a named beneficiary of such a trust, comes along and says, hey, mum and dad, this business that you've been running for the last 10 years, I'm a beneficiary of this trust because, hey, I'm one of your children. You're the primary beneficiaries. I'm one of your children. So you're supposed to have been considering me every single year. Where's your minutes that show you've been considering
real
me
and genuine consideration?
When you make a distribution from this trust. And most of the time people don't, in my experience.
Well, that's it. And you can just imagine those that have, that get their nose out of joint, and then all of a sudden they see an opportunity that they can go, well, hang on a minute, what about me? And unfortunately, in today's society, where it's a little bit, people are a little bit eager to take the litigation path, it kind of makes you cringe a little bit. As an estate planner, I have to cringe because I think, gosh, discretion's truly not the discretion that people often think it is. Yeah. It's not a free-for-all by any means, and I think Marsella is a perfect example of that. But it's certainly not just Marsella either, and there's a few cases on our list, as you know, Kate, that talk to this very point. But it certainly just makes you really stop and think, and perhaps this is something that as an estate planner, I know a lot of clients come to me and they don't understand a trust structure and in the real scheme of things. They, as you said, they've often been set up by the accountant because that's the way to do it and it's going to do this and do that. But often it's very common they don't understand how it works and what it all means. And so I think it's a really valid point to have that conversation with clients about what discretion actually means, and maybe keeping Marsella at the front of mind going, well, discretion's discretion, but it still must require good faith, real and genuine consideration. And even if it's discretion, it still needs to be genuine in the way that they approach it.
Can I say out there too, there seems to be a little bit of a misapprehension too among some lawyers that I've spoken to, that just because somebody's named a primary beneficiary of a trust, that somehow gives them some sort of elevated status to be considered for beneficial entitlements. And in fact, when you read the deed, most of the time it doesn't. All the beneficiaries are on the same foot as far as when you look at the discretion to distribute income, the discretion to distribute capital. Right. Yeah. Quite often there's no distinction to be made. It's not, that they should give first consideration to whether the primary beneficiaries should receive it. It's usually a case of they're drafted broadly so that they can be given the most flexibility that they possibly can. That's right. Because they don't want to be tying the trustees' hands as to who the income is or capital is to be distributed to, and that's the whole purpose of the flexibility of trusts. But if they are worded that it's just any of the beneficiaries, well, then it's any of the beneficiaries, that's including right. Well, one of that usually that catch-all phrase at the end, any charity that somebody may have donated, any of the above beneficiaries have donated to in the last financial year. Well, are you asking the beneficiaries who are named above who are the charities they've donated to in the last 12 months? Should we be considering those specific charities as whether or not we want to make a distribution to them? I mean, it's potentially endless.
It really is, isn't it? It's quite frightening when you think of it like that. But you're quite right. I think when people set up trusts like this, they think primary beneficiary really does have that elevated status, and it really doesn't. They are still simply an object of the trust, which are only going to receive something, provided the deed provides all of this, of course, and it is drafted flexibly. They're only going to receive something if someone makes exercise a discretion in their favour.
Absolutely. And the amount of times I hear my trust or Michelle's trust, and I go, you know what? It's not your trust. You don't own it, and you're not a preferred beneficiary in any way, and it's not Michelle's trust. She's just one of a number of beneficiaries.
Yeah, and I must say it's very common. I see the exact same thing, that my trust concept. And, but having said that, again, people look at their trust as though it is theirs, and they treat it as though it's their own bank account in a lot of ways. And that's why you really have to have that education piece with the clients, particularly in the estate planning context, because they need to be able to appreciate what the trust actually is. It's not theirs in the way that the money is in their bank or their money's in their wallet or something tangible like that. It is really just this house, this bucket that you might control, but you don't necessarily have an entitlement to unless someone says so. And that can be really quite a confronting conversation to have with clients. And so when you talk to that point of discretion and everything, yes, you want that flexibility. And I kind of often have said to clients, it's kind of like giving control to someone, but letting go of control at the same time. It's a really odd sort of feeling, I think, for them to try and grasp. But I think these cases really highlight that discretion, that you're handing it over to someone to control it, but they still have to abide by these rules, good faith, genuine, real consideration, and those types of things. So if you've got a really complex family dynamic, it can be a bit of a concern for a lot of people that there might be litigation about this later. And I think you're right. So superannuation is as you and I've said, previously offline, superannuation is a growing space for litigation. And this is kind of the reason why, isn't it? Lots of families, blended families, lots of reasons behind it. But I must say, I can't help but think this is why binding death benefit nominations are a valuable tool to try and overcome some of these, if in fact the self-managed super fund permits it, of course, and as you rightfully point out, provided it is validly made and it is a read the deed scenario, making sure you've got everything tidied up nice and well so that BDBN actually has a chance to hold on.
I saw a binding nomination this week that the trustee provides certain criteria as to what should be contained in the binding nomination, but there was no sort of scheduled form. But an advisor had simply just taken a binding nomination form that related to clearly another client of his and just used that form for the binding nomination in relation to this self-managed super fund, changed the names, etc. But ultimately in that case, I actually did come to the view that it was a valid binding nomination, but that was a very big starting point with a tick against it for a start, using a form that doesn't even relate to that particular fund. So
it's got to be done with so much caution, that those ones, don't they? Because as we all know, all the deeds are different, and they're consistently changing as well. So as the space gets bigger and there's lots of wealth and super, it's often a very big part of the estate planning conversation, and as such, as a result, a big part of estate litigation too. And Marsella is certainly one of the examples of that.
Yeah.
I think that was a great conversation about that case. So I reckon we can probably move on to our new little segment, which is the things I've learned. And I know, Kate, you wanted to share a little something that you have learnt in between our episodes and our last chat.
I did, Michelle. I wanted to share that I have only just recently discovered that the Uniform Civil Procedure rules in Queensland courts have changed to allow registrars to, if you subpoena documents into the registry, you used to have to go to a judge and get an order that you had leave to inspect and copy a document. But the rules have recently been changed and they allow the registrar just to permit the parties to be able to do that. So, which is a really good change. It avoids an application having been made. It actually makes the issuing of a subpoena a much more useful tool now in estate litigation. And I know they've been able to do that for many years in the family court. I've always been jealous of my family law colleagues who say, I'm just going up to court to inspect some subpoena documents. And, we always had to go and get an order from a judge to be able to do that. So it streamlines that process, makes it a lot easier. So, and I've only just learned in the last couple of weeks that we can now do that in the Supreme Court in Queensland. So just a tip for other litigators, if you weren't aware that we could now do that, hopefully that saves somebody else some time.
Yeah, that's very cool. I imagine you no longer have to have that jealous rage within you for your family law colleagues in the in the industry. But I can imagine that would be just such a great thing for a lot of litigators, and especially, of course, the courts and dealing with the lists and having to remove that need to go to all the way to an application just to do that. So that's really good. Well, thank you for sharing that. That's fantastic. I hope that certainly helps someone else as well in that space. I have no doubt it will. Well, look, I think we're going to come to a close on our episode today, but I do want to share a little bit about next episode with you all. And it's funny, we're talking about in Marsella today a lot about having a real and genuine consideration for beneficiaries or potential beneficiaries and when exercising discretion, because we're going to be talking about a case of the Re Marsella Family Trust next episode, which I will hopefully look forward to taking you through. And in particular, if you haven't been aware of this case, it's from 2020 in Victoria. And it was involving a family trust where a dispute arose between siblings about distribution. Well, a couple of things, really. It's quite a lengthy case. And if you've read it, good on you. I take my hat off to you. It's not a short case, but it's a case about the power of appointment that was challenged in terms of a number of variations that were made that were challenged about the appointer and guardian of the family trust. It was established many years ago. Mum and Dad has since passed away, and the dispute arose between the three surviving children and, of course, the trustee of the trust. And they challenged these variations where one of the children was appointed as the guardian and appointor. Not only that, they also challenged a number of income distributions over a number of years, and it was about 10 years, and talking about whether there was a real and genuine consideration of the objects of the trust in making or exercising that discretion. So it's a really good case, I think, to perhaps follow on from our conversation in Re Marsella today about what is a real and genuine consideration of beneficiaries when exercising discretion. So I hope you will join us for that conversation. I have no doubt it will be a juicy one because, again, discretion seems to be a really interesting focus at the moment, Kate. I don't know about you, but I certainly see a little bit more conversation happening in the space.
I think it does. And I'm also pretty excited that our episode following that discussion about Re Marsella, which I'm not sure if that's the correct pronunciation. I note that you call it Re Marsella.
Re Marsella. Sorry.
That's okay. But we're excited that we're going to have our very first special guest on the following episode, and we're going to be discussing the issues that arise out of both Re Marsella and Re Marsella or Owies. So if anybody's got any questions that they'd like to be put to our special guest expert in superannuation laws, let us know, send us an email, and we will hopefully have some really interesting discussion going on in that episode.
Yes, absolutely. I really would love to hear some questions you've got for our special guest. I'm incredibly excited myself as well. And hey, if you do have questions, please send them through to our email, which is hello@theairwaves.com. You can also find our website, theairwaves.com, and pop a question through there as well if you need. And, of course, all of our other episodes as well. Bonus points to anyone who sends through an email that tells us how to pronounce that case name. That would be super helpful. But, well, look, guys, we would really love to hear from you. So we might bring it to a close there. Thank you so much for joining us. We love spending time with you guys, and we look forward to chatting with you again in the next episode on the Airwaves.
Thank you, everybody, and see you until next time. And thanks, Michelle.
Thanks, Kate. I'll see you next time too.